So the U.S. Immigration Service just announced some major changes to the process of filing for a green card based on employment. Specifically, there might not be a need for the Perm labor certification anymore for certain occupations. Let's talk about this in this video. Hello everybody and welcome back to Immigration Channel. This is where we explain complex immigration matters in short, simple videos. We make immigration easy. And in this video, I'm going to break down the biggest changes that we've seen in employment-based immigration in the past decade. This is going to show you how certain occupations might not need the labor certification anymore and can proceed straight to the immigrant visa I-140. I'm going to explain to you which are these occupations, what these changes mean for you if you're part of these, and how it's going to be implemented in the next few months. So therefore, make sure you watch this video all the way until the end, because I'm going to give you some examples and we're going to go into the regulations so I can show you how you can qualify under these changes and how you can also eliminate the need for labor certification if you qualify under these regulations. Remember, you still need a job offer for this. This is for occupations and green cards that are filing under the EB2 and EB3 categories. But if you qualify under these new changes, you might not need to go through the labor certification anymore. Now, before we do that, if you're here for the first time, as always, make sure to subscribe to our channel, click the notification bell so you don't miss any of our videos, and also give us a big like so YouTube will be able to show this video to more people just like you. As always, if you need help with your immigration matters, all you have to do is send a text to 619-483-4549 and we'll be able to help you. Also, you can go to www.immigrationasap.com, leave your information there, and one of our team members will contact you ASAP. And now, let's jump into the video. So, what are these big changes that were announced by USCIS last week? Well, this is a major change to the way employers are filing green cards for certain employees. And the way it works is typically if you file a green card under the EB2 or EB3 category, the way the process works is step number one, the employer must obtain a prevailing wage and then file a labor certification. This is a process where US employers are proving to the government that there are no US citizens that are being impacted by the hiring. The US labor certification process involves advertising in the newspapers, online, and then filing the application with the Labor Department. However, there are certain occupations that are exempt from the labor certification. And traditionally, these occupations were nursing, physical therapists. If you're filing a green card for a nurse or a physical therapist, these occupations are exempt from the labor certification and they go straight to the immigration process, going through the I-140 application. Now, recently, under this new change, USCIS announced that they are adding science and art majors into this cluster to create Schedule A occupations for those people that are in these occupations, science and art. And as you can see on the screen, this is the actual announcement from USCIS about the change. And what it is that they're saying that for many employment-based second and third preference, EB2 and EB3 petitions, employer must obtain labor certification. And again, traditionally, it was reserved for nurses and physical therapists. And now USCIS considered that there's a shortage of occupations, a shortage of jobs in this area. And now they're adding science or art into our policy to align with the OL as it relates to Group 2. Essentially, they're designating Schedule A occupations to Group 2, which includes science and art. Any field of knowledge or skill with respect to which colleges and universities commonly offer specialized courses leading to degree in knowledge or skill in this occupation. So what that means is that if you are an art major and or science major, and now you're able to basically, and you go through the green card process under labor certification, you should be able to be classified as Schedule A, which means that they're not going to be able to need to file a labor certification for you when applying for your green card. Now, the way it works is that you still obviously need to have a degree either in science or art major. When we talk about science, it can also apply to engineering as well. But what that means is that you need to have that degree and that qualification, but you also need to meet additional requirements in order to be qualified under Schedule A and be able to waive that labor certification. And again, it's really important to understand that. And just because you're going to be an art or science major doesn't mean you're going to qualify automatically under Schedule A. However, just like with the nurses and the physical therapists before, you need to meet certain requirements. For example, with the nurses before, they need to be licensed, they need to be able to work in the United States. When it comes to science and art majors, there are certain requirements that you need to meet at least 2 out of 7 points to qualify for this. And let me go over those requirements. So as you can see on the screen, I have put together the list of the requirements of Group 2 of Science and Art, what you need to be able to show the USCIS in order to be classified as Schedule A. So let's look at it together. And again, this is from the policy change from USCIS and immigrants of exceptional ability in science of arts. Again, you need to be able to, if you're an employer, submit documents to show that a beneficiary has at least 2 of the following 7 criteria. And if you have at least 2 of the 7, then we'll be able to classify you under this category and then claim that you are not in need of a labor certification. So, for example, documents that a beneficiary received some kind of international recognized prizes or awards for excellence in their field. For example, if you're in engineering, maybe you receive some kind of award or recognition in your particular field. Again, we only need 2 out of 7. Another example is documentation, the beneficiary membership in some sort of international association in your field. So, if you're an engineer or an artist or a designer, there are plenty of associations that are in your field that are kind of organized in that way. And if you can show membership in those associations to show that you meet their requirements, then you'll be able to qualify. Another point is published material in professional publications about the beneficiary, about your work in your field. Again, it's not a requirement for you to have all points, but at least 2 out of 7. And these points are less stringent than, for example, national interest waiver or EB-1A. Evidence of the beneficiary's participation on a panel or as a judge of work of others. Again, that's very similar to the O1 or EB-1A. Evidence of your original work. Evidence of the beneficiary's authorship of published articles, and or evidence display your work in the field of art exhibitions in more than one country. So again, you need 2 out of these 7 in addition to show that you have a degree and you're professional in science or art. But again, I know that people say, well, it's kind of complicated and maybe we're not going to all qualify, but you'd be surprised. Like I said, quite a few people qualify for the national interest waiver. Quite a few people qualify for EB-1A, even though they don't think they do. So it's important to get evaluated to see if you also will be part of this requirements, and maybe you could also qualify and be able to waive the requirement of a labor certification. The point is that this is a major change because it's going to help a lot of people that are science or art majors that are working in the industry already for a few years, that are going right now through the green card process. Maybe they're starting Perm, maybe they're about to start. And if you qualify under Schedule A, under this Group 2, which is the new classification for science and art, you'll be able to waive completely the requirement for Perm labor certification. You're going to be able to save over a year from that process, and it's going to make the process of getting a green card much easier. So once again, I feel like a lot of people may be a little bit confused about this. It's a new regulation that just came out. It's a change to the policy manual, and it's really important to speak with an immigration attorney to be able to get an evaluation to see whether you qualify. Maybe you have those requirements. We can go over these 7 points with the clients and determine if and how you can get those evidence to show that you have it. But again, it's a major change. It's going to help a lot of people get out of this Perm process, which is very lengthy, which is taking forever, and obviously get a lot more people get their green card faster and without the need to apply for national interest waiver or the EB-1A because they feel like it's hard for them to do this all on their own. This is a process that still requires a job offer, but if you meet those requirements, you'll be able to waive that labor certification, which is massive, massive, massive news. So hopefully this information is helpful. Let me know in the comments if you feel that you can qualify, or if you want to get an evaluation. Send me a text, 619-483-4549. We'll be happy to help you. We're getting ready to speak with a lot of people that might be part of this and might qualify, and we'll be excited to helping you as well. Once again, thanks for watching, and I'll see you on the next video.